taken a little bit of a look on the need for harmonizing data privacy laws uh, across the world. Now, I think I'm too small a fry to attempt that or even try and build a case for that. I'm faced with a reality where 137 out of the 194 nations in the world have introduced data privacy laws in different shapes and forms. And therefore, talking about harmonizing is one thing, and of course, I'll touch upon it. But what is important is to see the reality which is staring at us, which is that the data privacy law, in whatever shape and form, is getting launched in various countries. And we, as multinational companies, have the onerous task of setting compliance standards for those laws as they get shaped in every single country that we are operating in. So the focus of this presentation is really going to be to talk about very quickly. Let me just touch upon the agenda. And as it always happens, there's a glitch, but I hope it's only in the beginning. I'm not able to move to the next slide, my friend. Okay. So what I'll do is I'll very quickly talk about and set the context of how data privacy came into being. I'm conscious I have only 20 minutes. We will just do a quick refresher in one slide on what are the key tenets of GDPR, what's happening in the region, which is all the territories, as we call it, Qatar, Oman, Bahrain, KSA, where the law has already come in force. Yesterday, there was, of course, some announcement. I'll talk about it. What's happening there. And most importantly, when the rubber hits the road, which is how do organizations really try and implement something as complex as this? Organizations who have customer databases running into almost 10, 11 millions, how do you get a consent? What do you do with cross-border data transfer, where there is a clear prohibition in many geographies or many countries? I think that's really what we should be talking about today, right? And of course, I'll not lose sight of what was the original, expectation. I will, of course, touch upon that, but I think I'll deviate more towards how do we really see this legislations taking shape in the geography and what should organizations be doing to implement the law as it comes through. Can we move to the next slide, please? So yeah, just a couple of slides on why this really started. This is a very celebrated case study. 2011, Target, which is a very famous hypermarket in the US, came out with this promotion. They were basically, it's all about targeted marketing, right? It's all about targeted marketing. So they were issuing advertisements to young ladies where through their consumption pattern, they were able to figure out what stage of pregnancy they were. When the father of one such girl received an email, he was absolutely shocked out of the wit. He goes to the store, he fights with the manager, and later on he realizes that actually there was some activity at home. His daughter was due in August, right? That was 2011. This was followed by 2012. Can we move to the next slide? Yeah. This is a very iconic picture of the Sony president bowing down in Japan. Customers, I think almost 2.5 million customer data got leaked, and they had to issue a public apology. Clearly, the systems were not robust enough. This is again 2011, 2012. So at the back of all of this, there was conversations about the need to have very strong data protection laws, and thus came. Okay, so there are a few more here. In the last 7-8 years, we have seen organizations, and trust me, these fines can really wipe out the bottom line of the organizations. So there's H&M, which has been caught doing surveillance of their own employees through gossip, whispering campaigns, creating almost a profile of all of their employees. That got leaked out. There's Google, where again, advertisement was happening, targeted advertisement was happening, but not proper consent procedures in place. Then there was WhatsApp, again, lack of adequate privacy notice, which led to a huge fine there. And finally, the mother of all, which was Amazon, Again, targeted advertising, not having the right consent procedures in place. So organizations have seen huge fines, and Middle East is going to be no different. One look at the laws which have come in different parts of the region, and all the countries, by the way, have framed the laws. They are in different stages as we speak, and I'll of course touch upon that as well in the subsequent slide. But as I said, just a very quick refresher before we get into the subject itself. We are aware of the GDPR and how it got issued in May 2018. These are some of the fundamental tenets of the law. And again, just quickly to touch upon it, the expectation is that the key principle, the first one, the collection has to be lawful, it has to be fair, it has to be absolutely transparent. The customer, the client, the employee must know what for the data is being collected. The consent, now whether it has to be an explicit consent or an implied consent, and how do you really deal with that consent? Organizations today, and I'm somebody who's at the receiving end of it, we have a customer database of about 13 million, right? And I'm only talking of this part of the world. And most of these guys, we are reaching out directly through our loyalty programs. But do I have an explicit consent? Possibly the answer could be a no. Now, it's one thing to go and acquire new customers and have all the processes and procedures in place. But how do you deal with a situation where you have a huge database? You haven't had explicit consents. And that's where the interface between IT and law really comes in. So we will talk about that in the context of Middle East. Purpose limitation, it has to be, as I said earlier, for the right purposes. It cannot go beyond the purpose, and that purpose must also get adequately communicated to the customers. Data minimization, take whatever is required. I have known of organizations, and I have been witness to an Excel sheet which has 500 line items of data pertaining to their employees. One employee having 500 line items of data. Does the organization really need all of that? What happens when the employee is terminated? Do you still retain all of those 500 line items, or do you start erasing that? There is a right of erasure, right? I'll talk about the rights later on. But data minimization is another concept which clearly is articulated in the GDPR. The data has to be accurate. That means it has to be contemporary. It has to be kept absolutely current. Storage limitation, integrity, and confidentiality. How do you, and that's exactly what happened to Sony, right? They were not able to maintain the confidentiality, the integrity of the data, because of which that fine came to them. And that's where the IT security, the whole data protection part of it. So one is data privacy, the other is data protection. While privacy is something that the lawyers really study about and advise the business on, data protection is really about data security and having the right IT systems in place to ensure that there are no DDoS attacks and there are no, those ransomware attacks that are taking place within an organization, which again lead to data breaches and possibly ransom demands on the company. Companies have to have the accountability. The rights of the data subjects, I think, is absolutely critical, and that's why I've kept it separately, and I will just talk about that. And the most important, data transfer. Different countries are coming out with data transfer regulations. KSA, for example, the Kingdom of Saudi Arabia, is allowing the data to be transferred, but it has to be for extreme conditions. It could be about the life of the data subject in KSA. It could be about health. In those situations, you can transfer data outside the country. But what happens to the customers who are living on loyalty programs in that part of the world? And all the servers where the data of those customers is hosted is either in Ireland or in EU, or it is possibly in one of the GCC countries. Can you not transfer data? And therefore, what do organizations like us do to ensure that that cross-border of data is not found to be violation of law? So therefore, the data transfer conditions have to be studied country by country, and that is where possibly there is a need for harmonization. I said I'll steer clear of it. It's too vast a topic. But one area where I really fret, how are we going to implement this law, is the whole bit around data. I do not have a cloud service provider in KSA today. That's the reality. The data of 5 million KSA customers is moving out of the country. That is also a reality. Is it going to Ireland? Is it going to EU? Is it going to India? Is it going to Bangalore somewhere? We don't know today. So organizations would really be required to understand which all places the data is headed to. Are those countries part of the adequacy list which each of these countries are really talking about? If you are part of the adequacy list, it's fine. If you are not, then you have to have a data privacy impact assessment to be carried out. You have to have the right contracts to be signed. And therefore, it's again a huge task for organizations which are, again, operating in multinational environment. That takes me quickly to the rights of the data subject, their right to information, right to have access to whatever information the companies are keeping about them. That's a right that is clearly given to them. Right to seek rectification of the data, right to be forgotten. All of these rights are embedded today in every single law that is coming in, and the organizations need to have IT systems where each of these rights can be exercised. I was going through, and I have been, doing a lot of reading up on this, plus also meeting a lot of external partners. Microsoft, for example, has an account for each of us. Anybody who wants to seek any understanding of what data Microsoft holds, you can go to the landing page or to your account, and you have the right to manage what all data do you have and what do you do with that data. You want that data to be modified, you want that data to be edited, to be forgotten, to be lost. All of those rights are clearly there in your Microsoft account, and that's how the bigger organizations which have billions and billions of customers, are possibly dealing with that. At our levels, possibly we are one step lower in terms of the customer database, but possibly some of those learnings can easily be picked up and incorporated in our own IT systems within the organizations. The right to data portability. Again, India talks about data mirroring. You need to keep a part of that data. The data needs to sit in India, even if it is getting transferred outside. And then, if I remember correctly, and my knowledge is a little dated on this one because I moved out of India, but I remember that you had to make sure that the critical data, there was a critical data, definition of critical data in the Indian law about a year back, if I remember reading it, which just could not be moved out at all. Now, how do you define that critical data? I'm not sure whether that has even come into being for the time being. So all of those things, I think, are embedded. This is the gold standard law. And as we go about reading up different laws in different countries, by and large, the provisions remain the same, with a few exceptions here and there. And I will talk about some of those exceptions in the context of Middle East. This is where we live, and this is what really matters to the people living in Dubai today, because all our operations are in these countries. As I go through how the law is getting enforced, KSA, the law was supposed to be implemented in March 22. The regulations came out about a couple of weeks back, and we were starting to prepare. Yesterday, the government department dealing with this came out with an announcement, a press release. They have deferred the law by a year, which was a bit of a sigh of relief, I must say that. Because in KSA, once the law comes in, it gets implemented and it starts getting enforced. Of course, they had kept a 1-year buffer for companies to implement. But as I said, data of half your company's customers is sitting, if it's sitting in KSA and it's not allowed to be transferred, that means you are just completely losing that customer database straight away, unless and until you go and get an explicit consent. Even if you get an explicit consent, there is a very good chance that you need a permission from the government to transfer that data. And let me tell you what is the board of that particular department looks like. It has the prince, and it has the minister of every single ministry, relevant ministry, whether it is commerce, whether it is industry, whether it is labor. Every single minister sits on that board. Now, if that entity itself is so powerful, that just tells me how critical it is for the kingdom to ensure or to keep tab on the data of its own subjects, right? And that gives you a wee bit indication of how seriously the government is taking this whole bit on data, possibly compared to the oil, I guess, in the KSA context. If I look at Qatar, the law is issued in 2017. There are 14 regulatory guidelines. They were issued in November 2020. The same has been enforced already. Bahrain, again, the law has been with effect from 2019. There are 5 draft decisions. The regulations are expected soon. And similarly for Kuwait, Egypt, and EU, we are at different stages, but the reality is staring at us. We know that in the next 1 odd year, we'll have the laws in place in each of these places. If I look at the requirement of consent, when I started reading the KSA law, Article 11 says implied consent. Yes, there can be an implied consent. The next article says that for advertising, marketing, promotion, you need to have an express consent. That's it. Because every single organization lives on that. The whole idea of targeted advertising is about acquiring customers and making sure that they can get the freebies that the companies are offering. Now, if for marketing and advertising, I need to get an express consent, what do I do with the 5 million or 7 million or 10 million customers who I have acquired over the last 20 years of my existence in KSA? Do I just let go of that database? I don't know. So that's something that's clearly a challenge. And similar provisions exist in the laws which have already come in. The data transfer, as I said, the companies cannot take their data outside the kingdom, and the kingdom is about 40 million people, right? Uh, Transfer is permitted only, as I said earlier, cases of extreme necessity, which are provided for under the law, and that also in some cases is subject to the permission of the government. I've already told you how the government looks like when it comes to the constitution of that board, right? And therefore, the chances of getting a permission to take data out, very minimal. So do organizations start talking to the Amazons and the Microsofts and the Googles of the world to ensure that there is cloud service providers being now hosted and hosting the data of the customers in Saudi? Or do we look at data being transferred outside into EU, Ireland, etc., which we are hoping are going to be called out as adequate countries? So that idea of whether these countries are adequate, are falling under not adequate, it's still open, right? So many of the organizations have those data sitting either in the EU, which is the safe zone typically, or it could be sitting in India, which maybe is definitely not a safe zone, and that's where the permissions, etc., will be required. So that's another area that we are watching out for. I will now, as I said earlier also, for me, I'm a very simple operational man, and that's what I deal with. For me, what is important is what is in it for my organization, and how do I ensure that I am substantially in compliance with the law. So what we did, we just went ahead and we said, let's map out what do we need to do in case this law becomes the law of the land for us. We have looked at all our, and this is, it says, somewhere it said internal circulation only, but I'm happy to share because there is nothing sensitive or nothing confidential about this data. This is simple knowledge that we have accumulated over some years, and there's absolutely no harm in sharing. I thought that was the whole idea of this conference, is to share a little bit about what we are learning in this whole process. The concepts. When I say landmark, just a quick context for the people who have just come in from India, Mumbai. It is one of the largest groups here. We are about 6-7 billion in turnover. The concepts that we have are Max, Lifestyle, Home Center, Homebox, Shoe Mart, Shoe Express. Some of these names, Splash, Iconic, which are absolutely household names here, and which means that there is direct dealing with the customers. And as I said, the customer database is absolutely huge. So we possess, and the fact is that we possess personal data of the customers, of our employees, of our third party. There are hundreds and thousands of vendors. There are suppliers, there are vendors that we are dealing with, right? Then there is the whole human resource. So there are about 55,000 employees. There is data of all of those, and this is where that's called the sensitive personal data. The racial, their ethnic origin, their vaccination details, their sexual orientation, everything could be known to the company, right? So that's the SPI. The fact is that the personal data is transferred across the boundaries. Wherever we have cloud servers hosting, that's where the data is sitting. We need to have formal arrangements with the third parties. There are so many of the data processors. While I'm the data controller, there are data processors. There could be an IBM, there could be an Accenture, there could be hundreds of folks out there who are our service providers who are managing that data. And therefore, to have the right contracts with those people to be able to hold them accountable as well. Applications are hosted on public clouds. I've talked about it. Where do these clouds sit? Are they sitting in safe zones like the Irelands and the UKs and the EUs of the world? Or are these clouds sitting somewhere else in one of the GCC countries, in Bangalore or in some other place, which may not be called out as a safe zone? If it is not called out as a safe zone in any of the legislations, which means I need to ensure that I have followed all the impact assessments to be able to get it ratified before the data goes into that cloud. Or the simple option is spend a lot of money and make sure that there is a cloud which is hosting your customer data in the geography where the personal data protection law has come into being. And finally, as I said, the loyalty programs. We have one such program called Shukran. We have about 10 million plus customers which are enrolled into it. And all of these customers' data is sitting with us, right? Having the right consent procedures in place is absolutely paramount, lest we should be found wanting on the compliance of the law. This is typically used to scare the business. I will not, this as lawyers, everybody knows, and I'm not going to, fret too much about it. The fines are such, I've just made one comment very in the beginning. The fines are such that can wipe out the bottom line of the company, period. So I will not spend too much time. There are different provisions, there are different non-compliances, and the fines for all of those are mentioned below. And this presentation is not for just my consumption. I'm very happy to share it if anybody wants it, right? Just 2 more slides to go. As I said earlier, this really needs change management. And this is not just the job of the lawyers alone in the company. The lawyers can interpret the law and help the rest of the teams almost build the right systems. And therefore, it has to be a marriage between the lawyers and the IT folks in the team, and with absolutely all the support coming in from every single function wherever the data sits. I come from an FMCG background. As I said earlier, I have worked all my life with Unilever, almost 17 years there, right? And for me, at that time, we used to have the R&D function where the customer data was coming in. We used to do clinical trials, and therefore all the sensitive data used to come from there. We had we used to say 4 out of 5 households in India use a Unilever product. And we know the population of India, right? So we know how many customers we had and how much of data would be coming into the organization. So identify. So therefore, what is it that we need to do very quickly? Identify the personal and sensitive. So this is called the data inventorization. Unless you know where the data is sitting, how do you go and comply with it? So the first things first is to know where all the data is sitting. Obtain the consent of existing customers, the most difficult part. We have not yet figured this out. We are reaching out to various partners outside to figure out what would be the right way. We need to have the right IT capabilities, but we need to also know whether it's going to be an implied consent or an express consent. And to that extent, advocacy comes in. We have now prepared a representation making an appeal to the Saudi government that in certain situations, implied consent must be allowed. There has to be a grandfathering of all of the customers who are sitting in my existing database. Unless the grandfathering is there, there is no way in hell I can go out and get consent of those 9 million people who are sitting outside, right? So therefore that advocacy comes in. Creation of a data privacy policy, again, very simple. These are some of the transactional things that need to be done. Ensure that the software vendors, third party, all of these guys are compliant with the law. Motherhood statement, when the rubber hits the road is when you really have to figure out how do you, solve for all of these. Make sure that only people that have access to personal information are the ones having the right access rights. Today, my HR data is sitting with every single HR executive in the company, and they're mindful of it. Why should an appraisal data be sitting with somebody who has absolutely nothing, with a recruitment guy? An appraisal data sitting with a recruitment guy is completely unacceptable. It has to be, appraisal is a sensitive personal information. If I got a 1 rating and that information is floating around in the HR community, that's a gross violation of my data privacy laws. Only the 10 people in the appraisal team ought to know what my appraisal was for the last 1 year. That's not the case in our organizations today, and that's the reality of it. Lots and lots of awareness. We have started this. Lots of awareness needs to happen within the organizations and the size and scale that I talked about. Please retain minimum data. I've talked about this also. 500 line items. Just remember that. I was absolutely stunned to see that Excel sheet. 500 line items on one employee, and God knows what all information, right from his village to what he wears to God knows what all. Right? Create a data retention policy, adhere to the timely deletion of documents as per the policy. Once a person resigns and goes, what is it that I need? Do I need 500 line items? I don't think I need 500 line items at all. So having the right understanding of what is it, the bare minimum that I need to retain, and finally having the appropriate permissions to be obtained before transferring the data. So that's that. And finally, last slide is something like this. Again, something that we tried to prepare, and this was more in the context of human resources, having a SPOC, a single point of contact for each function. What is the data inventorization that needs to happen, obtaining the consent. This is purely HR related stuff, nothing to do with the customers and the external, because that world is very, very large. As I said, it's millions and millions. We said, let's first, this is a lower hanging fruit. We are only talking of 55,000 people. Let's first get this right before we move on and go and do this for the rest of the customers. And having all of these things in place, there is a task force which is really figuring out how to at least get this right. Get this right, get the confidence that yes, we can move, sort of do bigger things, and then move to the customers. So that's it. I wanted to keep it in 20 minutes, and I'm hopeful that I was successful in that. As I said, harmonizing global standards is not something that a small fry like me should even talk about. I talked about the fact that 137 countries have come out with different legislations. Harmonizing them could take a century. What is important is to know the reality. The reality is that these laws, in whatever shape and form, are hitting us left, right. And we need to be clear, territory or country by country, how do we implement it if our operations are in that country. That's it. And that was really the whole purpose. And I thought, and that's why I tweaked the topic a little bit, just to make it more relevant for the audience. Otherwise, I could have given a motherhood statement, very broad-based speech, and left. But that was not what I wanted to do. So I sought an exception, and I spoke to the organizers yesterday. I hope it was of some use. And thank you so much for hearing me out. Thank you.